resume. Thank you very much. We have an excellent speaker, Professor Vicente Ortiz, Justice, public accountant, graduated from the Superior School of the Polytechnical Institute. He has a BA in law and a master's degree administrative right and fiscal right. He is certified by the University Camerino Italia in international law, and also he is member of the Lawyers Litigant of Mexico. He has a medal for his professional career by the Association of Litigant Lawyers of Mexico. He's the head of the program, radio program planning, intellectual planning, advisor of the UC&CS Global. Mr. Vicente Ortiz, Justice, we welcome you. Thank you to the great family of UC&CS Global for allowing me the opportunity to talk about relevant topics. And because of the great previous speakers, they are not afraid anymore of the technology. And as a result of this globalized world, because commercial interaction at agreement level made between countries, individuals, and the state. So every time we see vulnerability in the human rights, and on the other hand, we see the complexity that leads us because of the pandemic. The economies have weakened, so therefore the individuals sometimes fall in default, and the state as well. And we will find a series of controversies between individuals and the state. And derived from this, it is really important because practically we will fall at some point in time in legal uncertainty in several countries and too much controversy and a series of situations that surprise us. And each country has its own particular characteristics. I'm going to summarize some aspects under the morality theory. Now, that is not the case, but because uses and customs that influence a lot the human rights at an international level. I'm going to give you some interesting examples. But first of all, the background that I consider relevant. You have the material already. I don't know if I will be able to share it. If it's not necessary, the material is available and I can talk because information is here. We have studied it with so many important people around the world that have shared their experiences, allowing us to simplify some aspects. As a background, let me talk about on the 2nd of March of 1948, this is the preliminary start of what we could say the human rights, the American Declaration issued on 2nd of March of 1948. This document protected the human rights and internationally speaking. It doesn't mean that human rights themselves are not structured in ideas or principles, since the Roman law, the right to life, the right to liberty, but they were in some way established in certain type of evolution of those human rights. But we are talking about 1948, derived of 2 world wars, consequences made all the agencies to safeguard the life in the planet. This is how it was mentioned at the beginning of the world without humans will be tremendous. And this allows me to remember how the principle of law, which is the supremacy of the survival of the human race. And since human race tends to destruction, has to create something that would be on top of the man to control the emotions that leads us to self-destruction. That is why the will of people is never above the will of the law, and the will of the law should consider all the most basic principles that the human being has because of the simple fact of existing. And the simple fact of existing are things that the constitutions must recognize. There were many constitutions of many countries, and I would like to say a document, or I would like to say the supreme law. I do not want to talk about constitution in general terms because some countries do not call it constitution. So let's talk about this supreme law, and that there were many draftings in those supreme law in the countries that say that every citizen will enjoy the individual rights that the Constitution grant, as if the Constitution at some point in time could make us the favor in granting rights that we deserve as human beings. So this position was demanded by the international agencies to a degree that the drafting of the constitutions in Mexico on the 11th of June of 2011 that modified, so it says all citizens will enjoy the human rights that this constitution recognizes, because human rights belong to the human being for the simple fact of existing. So all the individual rights and basic principles are deserved by the human being. So in this aspect, we are going to address some comments. So the background: at the 10th of December of 1948, we have the Universal Declaration of Human Rights, also the International Pact of Civil Rights on the 16th of December of 1966. On the same date, the International Pact of Economic, Social, and Cultural Rights. And also on the 23rd of November 1969, the Inter-American Court on Human Rights. Practically, we have the foundation of all the feelings and that the mankind should consider to reintegrate the knowledge and synthesize the human rights as universal rights. Even though we're talking about matters at an international level, and with all this background, we shouldn't rule out in America way before 1948 and months after 1948, on the 10th of December 1948, this is when back then the duty and obligations of the man were issued. So we're talking about the human right. And for this, in the context of the Universal Declaration of Human Rights, we can define like the prerogatives that the human beings is a human person that can develop himself or herself in their daily endeavor. The basic right to life, to liberty, and the non-inhibition of the rights of actions that allow you, while you do not hurt the rights of others, to do whatever you want in the best interest with the best quality of life. Those are the basic elements that in some way defines the concept of fundamental rights and of the Universal Declaration of Human Rights. Well, this is the nice part. This is where we have the controversies. The controversies that I would like to convey to you, because the background will lead us to the complicated of the Inter-American Court of Human Rights when they see all those controversies, when we have the subtlety of the uses of customs of villages, where we see the complexity for what is acceptable for some people and what is not acceptable for other people. So let's talk about human rights that are divided into natural rights and all the rights that were acquired in society. The natural rights practically are the elementary, the basic, that as a person are inherent because of the simple fact of existence. We can talk about physical integrity, the life, freedom of movement, and the rights of the society. We will talk about the cultural, political, economic rights, and all the rights were communion and the coordination and agreement with other human beings. But in this social, cultural, and economic situation, I'm going to remind you something that you heard in the news. A group of girls that were fleeing from from Islamic countries, went to study to France. Obviously, in the University of France, the student does not have a cover in the face. They have to interact with the professor. They have to take a picture for a credential or for the. This is very common in the European world. So practically, they have to be dressed up with a Western style. So the use and customs of the Islamic women said that it was a lack of respect for the use of the burqa and the use of niqab. So just to remind you, the use of burqa is all the things that cover the face of a woman, like the niqab, but the burqa, you cannot see the eyes, and in the niqab, the eyes are uncovered. So the only thing that we see, so they claimed as an offense, and they demanded to be allowed to use the burqa and niqab in classrooms. So this they have to give in if they wanted to survive in the Western world. But what this leaves us is that regardless of the beliefs and the influence or the induction of the predetermination of the education of these girls, it doesn't mean that it could have been to accept the uses and customs and complain about the offense, the damage, or the inconformity for not using the clothes that they were used to wear. So, in this sense, if they claim a right, the right of freedom, the right of movement, in some way they were right, but they belong to social rights, to some collective rights, to political rights, where they should give in virtue that there's a different need under the Western characteristics that are different from that of the Islamic. So we need to consider individuality derived of their rights or uses and customs. So therefore, when incorporating to the world and wanted to coexist with the countries, it is impossible that human rights have transformation to adapt to uses and customs. That is why the Universal Declaration of Human Rights is to centralize the basic elements, minimum general for substances, with a sensitivity semi-subjective, as the great treaters said, like Locke, that mentioned the intersusceptibility, that without losing the values of the fundamental rights, we'll have to accept the morality and the uses and customs of certain countries, and they break in the scheme, or we break the scheme that they know, in such a way that this part of the sensitivity is what makes the processal part that in one sense is what we are going to cover today. Why this subject and why am I reaching this point? Because all the controversies in the world, well, practically we will end up by being in the Inter-American Court of Human Rights to safeguard some excesses of authorities against particulars. And in some way or the other, through the international agencies, we can safeguard those rights that we take care of, we want to protect, to continue in our life. So in this aspect, we can say, and in the slides, that I don't know if I can share my screen, if you allow me, but I wasn't told if I could share. Adrian kept quiet. No, you can share your screen, Mr. Justice Ortiz. Okay. Let's see. I don't like to distract myself when I am talking. It's because you are not... I don't know if I to make it bigger. I think that, okay, there we go. I'll come back so you will have all the material. So this is the first preliminary information of human rights, Inter-American, the Universal Declaration of Human Rights in 1948, as we said before. Originally in America, we have the 2nd of May, the definition of the Universal Declaration of Human Rights that defines the human rights, the natural rights, or the ones that are acquired in the society. What are the characteristics we should reflect in the world, in all the countries, as universal? First of all, the recognition that they are universal because every human being must enjoy of them, because they are worth around the world. They are original because they are substantial or inherent to the human being for the simple fact of existence. They cannot be a warranty to pay a debt. Like so many times something was paid with a life taken, but this is part of the historical evolution of human beings that leads us to the conclusion that the human rights that cannot be transferred.
And they cannot be transferred. You cannot waive to them. You have them just for the fact of existing, and they cannot be purchased, and they do not have any expiration date. They are permanent, while the human being lives, and that's the purpose of these juridical regulations for the human being. They are immutable. They are not going to change a long time. Some events are going to be adopted in procedures by the Inter-American Court to put them into the substantial regulation of the international human rights. How the safeguard of these human rights is exercised by means of international treaties that are not only in treaties. We can also find them in protocols, conventions, and also in internal regulations that should be recognized by the supreme law. Recognized, they are not granted. This is a word that is completely different. Source of human rights. No doubt the subjective part that we mentioned, the sensitivity of uses and habits. at the international treaty, that international treaty will have basic elements and social, cultural sensitivity from the state according to its own habits, and also the structure of these regulations should observe law and international laws. Obviously, also as a consequence of that, the experience in controversies and judicial judgments to safeguard in a proper manner and keep the hegemony in these decisions to protect these rights. And of course, the publicist doctrine, but that's for international law purposes. Somehow, it is recognized in the international world, and those are the ideal persons to establish all the doctrine literature for decision making in controversies at the Inter-American Court for Human Rights. Obviously, as we mentioned, as human rights are a word of sensitivity, they need to have special definitions for specific cases. Let's remind that in 1948, we needed to create some instruments to sanction genocide as a result of what we have heard for Holocaust due to all the damage and deterioration of human rights against the Jewish civilization in general in Europe as a result of the Second World War, and obviously in the Declaration of Children's Rights. One thing is that they are not subject to obligations and they have guardians, but they do have rights as human beings, and this is specified for minors. The minor also has the sensitivity that when they are minor, even if they are emancipated, some countries at 18, some others, and some others when they marry or they have their partner, and if they are 15 years, they are declared as adults, and due to uses and customs, they do not have children rights, but rights as any adult. So this universal declaration with sensitivity needs to acknowledge the particularities of some social groups that are established in the same nation. The United Nations statement is against any discrimination, and the International Pact of Civil Rights in New York, December 1966. The first protocol regarding territory asylum, Stockholm statement against mistreatment. I am just enunciating all the declarations and pacts and all the protocols that will perfect all circumstances or probable variables that historically become the experience that will conclude in the search of perfection to protect life and human beings. And as they say, like De Luca says, also rights, even if it's not a person but a thing, and they left a consequence of right, regardless the fact of the legal nature of any nation, and therefore also rights of human beings after life. So those are things that get perfected in order to give protection to life and especially to human beings. And obviously those that I mentioned are not the only ones. Those are just some of the main ones that are representative, and I am showing here some of them. Protection for indigenous peoples, and this was established at Geneva, and Rome Statutes. Now, which is the obligation of international right? Why they exist? To prevent human rights violation, the investigation and sanction people who have incurred in human rights violations, access to justice, provide legal resources, and also foresee probable repair for human rights violation. And this is going to be for jurisdictional or non-jurisdictional power, administrative, in order to establish these mechanisms that by means of the jurisdictional word will lead to execution, and then we can protect these points that we are mentioning here. Therefore, let's say that the structure of procedural law is established in an administrative part at the Inter-American Commission of Human Rights, which is, by the way, headquartered in Washington, United States. And as far as I remember, it is exactly, yes, Washington, D.C. There we find the Human Rights Commission, but it is the jurisdictional procedural part which is going to make decisions in the event of controversies at the Inter-American Court of Human Rights in San Jose, Costa Rica. This Inter-American Commission for Human Rights, now talking about the administrative part, is in charge of establishing and limiting the validity or nullity of any act. For the warranties of the human rights, and concretely at the American Convention of Human Rights, in terms of Article 26 of this Commission regulations. And in the event that there is no other international instrument, it seems that it surveys all the structure representing the validity of actions in the area of human rights. That's why it is not a jurisdictional organization, but an administrative via that can have preventive actions, also corrective actions without coming to controversy, and mediation, or, well, new agreements or modification of some points that could be modifiable without altering values of the Universal Declaration, and those that are considered as universal that may be adapted to prevent to come to a conflict and finally to a controversy. And why this is sought? Because if I come to controversy, probably in the interim, while we have this action, juridical action, or any action as a consequence, it generates human rights violations. When we come to any controversy, we have irreparable damage. Therefore, by means of the Human Rights International Commission, we seek to establish agreements, criteria, and many other circumstances that could serve as a part of an experience to reach to these events that deteriorate human life, and then the legitimate holder of these rights that were violated can be reclaimed at the Inter-American Court, but in some instances it is impossible, and somehow no justice can be done. They are just sanctioned then we generate the backgrounds for future successes, but it is not really punishing the responsible. We try not to have violations to human beings, so there was not a preventive stage, no dialogue or any agreement or any proper mediation, and therefore damages took place that will be then debated in a controversy. But in many of the instances we have some violence, collective violation, then it is really difficult to repair damages, since it is really very likely that we have losses of human beings. And now let's get into our goal. First, most of the members are accountants, and lawyers will understand this in a better manner. Before getting into this, I would like to explain the following. In our procedural action in many subjects, we need to start with the effectiveness principle. What does that mean? If it has to be exercised, I need to turn to all the instances from the lowest to the highest. And if I cannot go to the second instance, next and finally to the highest, which is the defense of human rights and constitutionality of each country. And if given the case, all these mechanisms were depleted to look for justice implementation and no success was obtained, back then we can incorporate this request or this complaint to the Inter-American Court of Human Rights. In many countries there have been some backgrounds that the court has sanctioned states due to damage or non-complete repair of this damage. And in some cases, as in the case of Mexico, it becomes a precedent for the time where we can define the periods of the Supreme Court of Justice to establish case law and generate this precedent. In some countries, we have these mechanisms that supplement an extra official action, very particular of transcendental nature, and then modifies a period and the story in which the justice will be implemented. But one of them could be the controversy or the fact that the Inter-American Court in this so special case can become the representativity of a particular state that comes to the court, and obviously the state is going to be sanctioned. To come to this Inter-American Court, we need to deplete the effectivity principle. We need to take all instances up to the amparo or injunction law, and in the worst of the extremes, if it is lost, knowing that there is a violation to human rights, no doubt the Inter-American Court will intervene, and we may request for such intervention, but we first need to turn completely to all interior instances. If this principle would not exist, then we would turn to this principle, but we would be really violating sovereignty. So we need to involve them in based on the treaties that we have mentioned and some other legal treaties of international nature, that the international intervention is when we have imminent violation and the damage is not repaired by the warranties of the country. Therefore, the Inter-American Court is a judicial, autonomous institution whose purpose is to apply and give interpretation of human rights and it applies some of these functions and the statutes to establish this mechanism. And once these internal instances are turned to, then we are going to go to the court, and this should be based in a procedure that has its own regulations at the own court. Therefore, this court is made up by 7 judges of member states, in this case American states, that are elected among jurists of excellent quality according to Article 52.1 of the Convention, and also the Inter-American Human Rights Commission. And what happens here? It could also be that these 7 judges need to provide attention to any matter that corresponds to the nation of that judge. At this point, the rest of the judges can appoint a substitute from their own countries to destitute that judge that could have a conflict of interest that would belong to one of the nations in controversy, or also of any particular in the state of the same nation. And obviously it would have some impartiality according to the statutes of their own court. And another person can be appointed by means of the regulations and statutes that could be provisionally exerting the action of the judge, and then those that could come in the position for 6 years in order to have elections. What happens in this sense? What's the importance of this matter in these conclusions that we have drawn in at this yearly appointment? Let's pay attention. Let's read all these international treaties, agreements, and human rights that each one of you somehow know them, practice them, and can see them reflected in their supreme laws. However, procedures that are specifically targeted to this protection and safeguard of interests, let's think from the accounting world, when this controversy comes to an extreme case of non-resolution, and with this amparo, or at some point the state in a dictatorial attitude is not observing this sentence of the Supreme Tribunal, and it is not partially or completely remediated the rights that were given the protected right, then we would need to turn to these instances for the human rights in many countries, when now, as a result of the pandemic, lack of resources, desperation of many authorities due to taxes at respective nations, this is affected by the lack of capabilities by companies, and many of them have come to bankruptcy. They were forced to close. International process that has been limited by collective interest, demanding closing businesses to prevent contagion. This is a major good, and we are closing guarantees, but we still have collateral damages because families are also being damaged because they cannot exert their production, consumption habits, and in one or another way, they were damaged in their health, integrity, and dignity. And now, talking about this collective interest, probably there was some excess. And I am not underestimating the case that in the case of taxes, authorities could also incur in excesses with individuals, and through these management and handlings or juridical strategies that are established in this interior controversy have not been favored, even when there's a violation of warranties for human rights. This is this will force where we do not have any balance in this equilibrium. Some of them could be favored, but some others could be damaged, and we can say that everybody has been affected by this particular situation. We know about that. The new normality is leading us to very new situations, and not for this they are going to be exempt of some abuse, probably not in purpose, but this is going to damage some aspects of human rights. And then this is going to be part of the opportunity areas, as it was mentioned. It was said that what shall we expect? And I have said that the accountant will still be one of those necessary characters to contribute in decision making, with the specialization and perfection of many opportunity areas in this multidisciplinary world of globalization, and not foreign to this knowledge and management of human rights that in administrative matters can contribute, and this is a very high opportunity area, to establish internal opportunities for those that work or have the opportunity of human rights. And there are many controversies. The fewer controversies are there in a nation, we are going to have more investment opportunities, and therefore more juridical certainty and an active participation in that country. To the extent that we exteriorize juridical certainty, we are really scaring investment. And even when new normality and technologies, we would have some issues in this nation due to the fear for violation of individual and collective warranties. So we need to acknowledge these points, and many at academic level and jurisdictional are seeing the need to have this kind of situations to this international organization. They are not the only ones. In this globalized world, we are in the need of using them to safeguard our interests. In fact, my fact was to demonstrate that in a few words, of course, you cannot speak about everything, and I try to simplify this in a simple manner, so in this way we can have an opportunity area and say to our colleagues, friends, lawyers, that this is a part of the globalized world, part of a process that could be auxiliary. So with any action we can demand strengthening and juridical certainty by supporting international organizations, providing more factibility to have a nation with economic process, regardless the fact of all the capabilities for what our dear colleague mentioned with this excellent previous presentation. So we need to become exponentially thinking to evolve as a nation, but not only in the technological part, but also in the human part. So the economic part is growing for new generations. Thank you very much. With this, my participation is completed, unless we have any complaint or comment.